Hey everybody, happy Monday. What's going on? Hello, my friends. Hi, girlfriends. What's up, everybody? We got a new member. Okay, Granny the Great, 221. Don't play with her. Thank you for making it official. Thank you so much. Period. I appreciate you investing your coins in this channel. Thank you so much. Okay, guys, Sarah Boone is getting ready to get her ass served on a not so Thanksgiving platter. Today the Torres family can hopefully start to move on from this nightmare of, what did they call her, a blue-eyed dragon? The Torres family did not mess with Sarah Boone at all because they knew that she was trouble. They knew she was about that bullshit. And you know when someone comes over to the house with one of your loved ones and you know they ain't right. Sarah wasn't right, guys. Sarah wasn't right at all. Sarah was crazy. Sarah is a mess. Okay. And she's getting ready to get her ass served. Okay. I had to pull some video. Hopefully, let's keep our fingers crossed, guys. Just send up a little something right now so that StreamYard is not going to sabotage another show of mine. Please take that shit somewhere else. Okay, I've invested a lot of money in StreamYard. StreamYard, you need to, if you're gonna act up today, act up elsewhere, please. Okay, we had enough of it this morning, so let's see how it goes, guys. I don't know. So this man right here, who's this guy right here? His name is Andrew Bain. He is the state attorney of the 9th district in Florida. Okay, he is Mr. J, who's standing right behind him, the wonderful prosecutor. That's his boss. Okay. That's the boss, Mr. Andrew Bain. Let's hear a few words from Mr. Andrew, State Attorney Bain. Okay. You might recognize him. He is, like I said, he's over the 9th district and he's over Osceola County too. He is going to be responsible for Stefan Stearns too. Okay. He is the head honcho. Okay. Let's hear what he has to say.
Sarah Boone was convicted of second-degree murder of her boyfriend, Jorge Torres Jr. These events stem from an incident from February 23rd of 2020, where she zipped her boyfriend up in a suitcase in what she claimed to be a game of hide and seek. And 2 videos were introduced from her, where he was begging for his life, and a horrific turn of events. And she didn't try to let him out. She didn't do anything to help him. She just went upstairs and went to sleep. And so this is a very horrific homicide. Nobody really should have to endure this type of struggle and fight for their lives and have to die alone, begging for their last breath inside of a suitcase like this. And the jury did amazing work. I'm thankful for our chief of homicide, Will J, and our assistant state attorney, Dave Cacciatore. They did amazing work. Some of you caught me in the courtyard I was like, I get briefings about it every single day about what they've been doing, but we're excited that they were able to bring this home with a victory because today justice was served with the conviction of Sarah Boone for this very horrific homicide that occurred. And so, if you have any questions, I'm gonna turn it over to
So
them.
strong. Oops, sorry.
The defense's argument, clearly the jury did not buy
Correct.
it. The argument was self-defense and battered spouse.
Correct. And so we're going to turn over to Will and Dave to ask all specific questions as to all the defenses, because they did all the great work, so they deserve all the good credit.
Step up a little bit? Thank you. Yeah, so like the defense, can we speak about that? I know the jury obviously did not buy that. They came down with that second-degree murder charge.
Correct. Yeah.
Well, how does that make you feel? Did you get a chance to speak to the family?
Yes, we're very happy to gain some closure for the Torres family and some justice for George.
Strong closing arguments from the both of you today. What do you think, like she said, this case means for the family and getting justice for George Torres?
I think after 4.5 years and the numerous delays, I think they were finally just happy to see this case go to trial and be able to put this one in the books.
What do you think the appropriate sentence should be?
We'll reserve comment to the sentencing hearing.
Do you expect the verdict to come back that quickly? I think it was an hour and 20-something minutes. Very fast.
Should never have expectations.
What do you think about the case law with respect to Martinez? I know there was a strongly worded letter you all signaled you will be sending. Is that right for judicial review higher up?
Can't really talk about future legal arguments.
Mr. J is giving nothing.
Between you and James Owens, or
Mr. J is like,
and then also
negative.
levity, was this different than a typical battle that you go into?
I wouldn't say it was different than a different relationship than with most defense attorneys.
What would you say to the jurors who were here for about 2 weeks on this case? It was a long jury selection and then, of course, a lot of evidence to look at and all of that. What would you want to say to them?
Just thank them for their service.
Will, did you know that it was George Torres' mother who broke down in court today, and that was the reason for the bit of an outburst?
I was made aware afterwards. It happens in these cases.
Do you have a chance to talk to her and say something to her?
I have not yet.
How about you, Dave?
I spoke to her along with the rest of the Torres family after the verdict, and just listened to them.
A strong rebuttal yesterday from you guys. What do you think that evidence showed the jurors and meant for this case?
Not going to really talk about the evidence.
Final question from me is, are you stunned that she did not take that plea deal?
It's not for us to say.
Thank you, gentlemen.
Mr. J is like, look, don't ask too much because we're not telling anything. Okay. So so I've been looking for this for a minute. So you guys know, anyone who's here, you watch the trial, the days after the trial, you know that Owens filed a motion for a new trial on November 4th, right? Girl, no answer. Hold on a second. Let's go to the docket. My favorite place. The docket. Let's look at the docket, guys. November 4th. Motion for new trial, right? Who dropped the state's response today? Girl. Now, the psychological evaluation was under lock and key. This was under lock. This one was under lock. I sent my credentials to get access, and I have not been granted my access yet. Hopefully, I mean, it won't matter. We can always look at it once access is granted. Any document that falls under confidentiality statute is therefore only viewable by certain users. So I don't know if I'll be able to get access to it or not. They may make it public later or not. I don't know. We can only hope, but it was filed today. The psychiatric or psychological evaluation probably would be very interesting. Once they admit it into evidence, maybe it becomes public. I don't know. We can hope, right? The state's response has been filed. Yay! Let's hear who wrote it. Let's see. Was it Mr. J or was it Mr. Cacciatore? Let's see. I'm sure it's going to be full of snark. Will Robert J filed his response from the state from the Ninth Judicial Circuit in and for Orange County, Florida. We're going to get into it. We have about 30 minutes before court starts. Guys, excuse me. I went to sleep in a sinus frangru, okay? I started having a frangru in my sinuses, and it has been 24 hours of annoyance. So excuse me for just a moment, please, while I try to handle the business, and I will be right back, okay? Okay, I'm back. All right, let's get into it, guys. This is the state's response to James Owens and Sarah Boone's request for a new trial. Of all the nerve, okay? Ma'am was found guilty by a jury of her peers and selection, and had the nerve to try to cost the state even more money. The judgment recorded and filed on October 25th. By November 4th, they were already filing for a new trial. Anyway, let's get into it. We'll try and get through as much of it as we can. 13 pages, so it's not short. Let me get over here to where I know the... And then we're also still on verdict watch for Mr. Kendrick and Mr. Jackson, if you're nasty. Kendrick Jackson, verdict is waiting. Komorowski, I guess they're going to call to order court. I'm assuming, Jamie Komorowski, I'm assuming it's going to be jury selection today. I would imagine. I don't think that this is like day one. So I would imagine it's jury selection. So we're not necessarily missing anything yet. Let me get over here to Boone Watch. I just want to have it on my other screen so we're not missing anything if they get into court while we're waiting. Let's see. Okay. Let me hit my notify me now. Notify me now. Okay, there we go. We're going to hold this right there. We have about 30 minutes. Welcome, everybody. We are going to read the state's response to defendant's motion for new trial. Comes now the state of Florida by and through the undersigned assistant state attorney, and states allege the following. This ground is based upon things that occurred well before the trial began and does not appear to be a basis for the court. So I think Kranick is probably going to rule on that today. It's quite possible. So just stand by for that. That's why I want to read it before. So if they, so we can get a key, because he's probably going to say denied. Okay, trial began, does not appear to be a basis for the court to grant a motion for new trial under Florida Rule Criminal Procedure 3.600. The court's decision is on the ground well-based, supported by the facts and law outlined in the court's 16-page order dated June 28th, 2024. So they're going back. they're telling the court you can't even make a decision based on the grounds that Sarah Boone and James Owens filed on, because back on June 28th, you filed an order, and based on that, the court's decision on this ground is well supported by the facts outlined. So basically, as you're reading this, go back to your decision on June 28th, and the answers are right there to deny this order. Okay. So Mr. J is basically telling the court that you already have the answers because you already mapped it out on June 28th. The court should not grant a new trial based upon this ground. Ground two. So number one, the ground to not file to grant a new trial, court ruling defendant not entitled to court appointed counsel. So she had chanced herself out based on her shenanigans. That was number one, and that was outlined by the judge on June 28th. Number two was court denying defendant's motion to continue. The ground is based upon things that occurred before the trial began and does not appear to be a basis for the court to grant a motion for a new trial under Florida Rule Criminal Procedure 3.600. The defendant is overstating the holdings of the case. She cited Prezzo versus State 356 Southern 3D 831. So all this case law, McKenzie versus State, Jones versus State, Deal versus State. The court shall not deprive a defendant of his or her right to counsel of their own choice. Failure of the court to grant a continuance will result. And keep in mind, they're saying that the court deprived her of her right to counsel. The court told her she would no longer have a right to a public defender, to counsel provided by the state of Florida. She had counsel. She had James Owens. She had James Owens and several lawyers. So it's not that she was deprived to her right of counsel. She had counsel. So it's like, what are you saying? Because she was deprived to the right of paid counsel. So it almost makes you think that I don't know. It's like, it's not that she didn't have a lawyer. She didn't have a lawyer for a period of time, but in the trial, she had a team. So it's like, what are you talking about here? Failure of the trial court to grant a continuance will result in a new trial should the court deny said motion for a continuance by new counsel is not the holding of these cases. The defendant's right to counsel or of his or her choice is not absolute. The court's consideration of any continuance should balance the defendant's right with consideration of the impact on administration of justice. And she did end up having counsel of her choice. She put out an advertisement and she got an attorney and didn't have to pay for it. And the state didn't have to pay for it. So where is the lack of attorney? Any denial of continuance to obtain new counsel must be based upon an adequate inquiry into the circumstances with finding the assurance that the defendant's constitutional rights were not being deprived. The court's 16-page order dated June 28th adequately addressed the circumstances of the defendant's forfeiture of her right to counsel and the setting of a trial certain date of October 7th, 56 months after she was arrested for this crime. The court did not abuse its discretion by denying a continuance in this matter. The case was over 4.5 years old because the defendant's issues with multiple prior attorneys, issues created by her behavior. The underlying work on the defense and of self-defense and battered spouse syndrome evidence to be used in support of a claim of self-defense had been done by prior counsels. Much of the records disclosed to the state in October 2024 had been acquired years ago by prior counsels via subpoena and provided to private investigator Billy Lane. So basically, he's also saying that this defense was a defense that had already been formulated and worked on. And it's not like he didn't already have part of the case already handed to him. So it's not like he wasn't able to defend her, didn't have the information. This has been the strategy all along by previous attorneys. Most of the information provided was information that had been acquired and turned over to this attorney from the other attorneys previously. The Florida Supreme Court requires that only 30 days notice prior to a trial for a defendant to rely upon battered spouse evidence. In this circumstance, with the expert already working on the defense case for years and relying upon defendant on relying upon records the defendant had in her possession for years. It was the state that had only 30 days to handle this evidence after prior counsel had indicated it would not be filing a notice of intent to rely on battered spouse syndrome evidence. While it did take time to review the entirety of the defendant's phone extractions, the state was able to do so in the same time frame and narrow it down to 167 pages of PDF timeline and 213 photos. The phone extraction had been provided years ago to the defendant's prior counsel. It was again provided to the defendant while she was pro se. The 911 and body-worn camera footage from the prior incidents took approximately a half day to review, and that was accomplished after it was learned on October 1st, 2024, during her deposition that Dr. Julie Harper relied on them. These were provided to the defense on October 4th, 2024. There was an entire week of no action taken by the court between October 7th and October 14th due to Hurricane Milton. That and the prior 5 weeks was more than sufficient for the team of 4 attorneys and a trial consultant to review the material if the undersigned could. The court should not grant a new trial based on this ground. Ground 3, homicide survivor outburst during the presentation of evidence. During the publishing of an exhibit which contained image 0162, apparently a single family member of the homicide survivor had an emotional reaction and left the courtroom. The undersigned's back was turned and did not witness this. The family's member did not return for the duration of the evidence presentation. It cannot be said that this nonverbal single emotional outburst was so prejudicial so as to wait, did I just lose my place? I'm like, where am I? I'm sorry. So prejudicial as to vitiate the entire trial, and cites Talley versus State, Thompson versus State. Single outburst by a victim during a trial did not vitiate the entire trial. The trial court's finding on this situation are subject to an abuse of discretion standard, and the court did not abuse its discretion. The undersigned recollection is that at sidebar there was no request for a curative instruction, but rather a request to excuse the jury. The jury was excused, and the member of the victim's family had either excused herself or then excused herself. The allegation was then made that this was intentionally staged by the state. It was neither intentional nor is it uncommon that a homicide survivor who has the right to be in the courtroom pursuant to Article I, Section 16 of the Florida Constitution was mistaken in his or her belief about his or her ability to not become emotional during the trial. Nebregal versus State is distinguishable. There, There, the victim deliberately testified about DNA evidence on her buttocks belonging to the defendant when in fact it was not the conclusion of the DNA analyst, whose findings were inconclusive as to the identity of the evidence found on the victim's buttocks. Cologne versus State is is also distinguishable as it involves the mother of a sexual battery victim apparently needlessly being shown a picture of her daughter's private and showing and throwing up in a trash can in the presence of the jury. There, a mistrial should have been granted. There, maybe that was a typo right there. Uh-oh. Should have been. Okay. Smith versus State involved a case where a medical examiner took a breath while testifying to the injuries of the decedent had sustained and asked for a break. No error was found in the court's decision to not grant a mistrial. Ground 4, Dr. Warner's testimony. So the state is touching on all of the reasons why Mr. Owens stated in his motion that there should be a mistrial, and they're just going point by point as far as why they don't believe that this is so. Okay. Let me see. Okay. All right, guys, I'm going to flip back over and try and get through the rest of this because we're only on page 5. If we don't finish it, we'll finish it when we're done if it still applies. Okay, so number 17, the state understands the court's ruling at trial on this matter of whether Dr. Warner's opinion about the inapplicability of the battered spouse syndrome evidence as a concept was a discovery violation and is not revisiting it for that purpose. Rather, the defendant has included this in her motion for a new trial, so the state will readdress it. The state is not required to disclose unrecordable oral statements unless it materially alters a prior written or recorded statement previously provided by the state to the defendant. The state deposed the defendant's expert, Dr. Julie Harper, as soon as possible after she was disclosed. The deposition occurred October 1st, 2024. The very next day, Dr. Warner evaluated the defendant at the Orange County Jail at noon, October 2nd, 24. Given that trial was set to begin October 7th, 2024, this was less than ideal for the state. The state was not provided the materials that Dr. Harper had relied on at the time, although the defendant acquired much of them years earlier. Dr. Harper's deposition had not been transcribed yet for Dr. Warner's review prior to the evaluation. The second defense expert, Dr. Michael Brannon, had not been deposed yet. After the defendant, in most material aspects, repeated her statement she made to Dr. Julie Harper that she zipped the victim in the suitcase and that they both initially thought it was funny, but she became angry after the victim stated he could not breathe. So she became violent with the victim and ultimately left him in there despite his stating he could not breathe and demonstrating his inability to get himself out of this predicament. It was Dr. Warner's conclusion that battered spouse syndrome evidence would be inapplicable. Immediately after the evaluation on October 2nd, both parties and the defendant went to the court to argue the defendant's motion to suppress. On October 3rd, the state began reviewing prior interactions with law enforcement that Dr. Harper said she had relied upon during her deposition on October 1st and arranged for body-worn camera and 911 calls to be provided to the defense team by ASA Dave Cacciatore on October 4th, 2024, while the undersigned was in Osceola County handling a placement hearing on a not guilty by reason of insanity first-degree murder case. Later on October 3rd, the undersigned took the deposition of the second battered spouse syndrome expert listed by the defendant, Dr. Michael Brannon. On October 4th, immediately after concluding the insanity placement hearing in the morning, the defense team took the deposition of Dr. Werner. Mr. Owens pressed Dr. Werner for any other opinions she may have, and Dr. Werner insisted on being asked specific questions. This is not a discovery violation nor a creation of a prior inconsistent statement. The victim's failure to mention the two incidences in response to the defense counsel's open-ended deposition questions did not amount to a material change in testimony from the videotaped interview with Detective Martin. Detective Martin's report or the victim's deposition, because the victim's unrecorded statement did not materially change her previous testimony, the trial court ended the inquiry and properly concluded that the state was not required to produce a statement to El Gomari. Emphasis added. It is indistinguishable from this case. Furthermore, the defendant was repeatedly placed on notice that the state did not believe, as a matter of law, that her statements taken in the light most favorable to her amounted to self-defense under Florida law. A decision was held immediately following Dr. Werner's evaluation between the state and the defendant's lead counsel. To this effect, the defendant's lead counsel expressed that he believed the state should be lowering its offer of 15 years in the Department of Corrections because of what we had all just witnessed the defendant say. The state viewed the evaluation very differently and let the defendant's lead counsel know why. Further litigation ensued immediately thereafter on the defendant's motion to suppress statements. The defendant in her motion states the witness had formed a new opinion relating to whether the defendant perceived an imminent threat at the time of the offense. The issue was discussed extensively in the expert's witness deposition taken on October 4th, 2024. The word eminent does not appear in the entire 87-page deposition. It was not discussed. What the defendant stated on page 78 of Dr. Werner's deposition, according to Dr. Werner, was, and she said, I saw him in a suitcase and I zipped him up and we were laughing. She said, then he said he couldn't breathe. And I remember feeling I couldn't breathe when he was choking me and sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. Damn. She shook it, she lost control, and then it flipped. Okay. Because she was never questioned on that opinion, there were no inconsistent statements to impeach Dr. Werner with. Hypothetically, if the defendant had gotten Dr. Werner's opinion on the matter during the deposition, the state fails to see what the defendant could really do with it other than disagree with it, because Dr. Werner's opinion did not violate Florida statute 90.703, no more than when Dr. Werner rendered the opposite opinion. It was not an opinion on whether the defendant was guilty or not. It was not even an opinion about whether the defendant used a justifiable use of deadly or non-deadly force. The opinion was, about the inapplicability of battered spouse syndrome as a concept given what the defendant had told her in her evaluation, and that because of what the defendant stated in the above paragraph, it was inapplicable even if the defendant suffered from battered spouse syndrome. It was no different than Dr. Harper stating that the defendant met the criteria for battered spouse syndrome and that the defendant telling her she was in imminent fear at the time the defendant left the victim zipped shut in the suitcase. Experts can testify that a victim's injuries are consistent with forced sexual intercourse. And then mentions Kraus versus State and Fernandez versus State. Experts also routinely testify about the applicability of the insanity defense to a defense. Experts routinely called to testify regarding the defendant's sanity is precisely these terms, the jury's instructions on insanity. Medical examiners routinely, as in this case, testified to the case of death, to the cause of death, and it does not invade the province of the jury. It is in opposite. It is in opposite that the medical examiner's testimony contradicts the defense's theory of the case. This is what happened here. Dr. Warner disagreed with the defendant. Because the defendant was examined by her own expert, Dr. Julie Harper, complied with Rule 3.216E and F, and was examined by Dr. Warner, both experts were allowed to speak on the applicability of the battered spouse syndrome regarding the facts of the case, State versus Hickman. The relevance of Dr. Warner's not listening to the testimony of Dr. Michael Brannon and Julie Harper is lost upon the state. Ultimately, regardless of what all three doctors in this case testified to, the crux of the entire case was that even accepting the defendant's trial testimony, which was largely consistent with her statements to Dr. Harper and Dr. Warner, she failed to comply with Florida Statute 776.041 and in fact escaped having the forcibly felony instruction read because of the statute of limitations technically, at point which opposing counsel agreed with at the charge conference. This argument was permissible regardless of whether Dr. Warner testified or not. As a remedy, the court allowed the defendant to question Dr. Warner about opinions she was not asked by the state to give to the jury, specifically whether the defendant suffered from any disorders recognized by the DSM-5 TR or met the criteria for battered spouse syndrome. She gave the following answers to the following questions during her deposition. Okay, all right. As it relates to Sarah Boone, do you have any diagnosis as it relates to her? No. She told me she was previously diagnosed with generalized anxiety disorder, so that would be in there. So that would be in there. She's been prescribed an anxiolytic for that to help treat her symptoms. Whether it is generalized anxiety disorder versus an adjustment disorder to her being in a facility is questionable for me, in all honesty, but I haven't had time to go through everything thoroughly since I just saw her 2 days ago and process everything in all honesty. I think she also has narcissistic personality traits was evident in her evaluation, and those would be my two major diagnoses. So page 46, but you don't believe she suffers from post-traumatic stress disorder in your opinion? No. I would have to look through the back of my notes to see if she fully met the criteria. In your opinion, that Sarah Boone does not suffer from battered spouse syndrome? No, again, I have to go through my notes to fully formulate an opinion on that, but I think she certainly was involved in a violent relationship. But you haven't formed an opinion one way or the other about whether Sarah Boone suffers from battered spouse syndrome. I think I want to go through it to make sure, but I believe that there was a lot of violence in her relationship. She described being threatened. She talked about, you know, the different kind of violent cycles and the different aspects of it. So most likely she does. I don't have an issue with that. At trial, the defendant was permitted to explore Dr. Warner's opinions on these matters. The defendant was also without objection to bolster Dr. Harper's testimony by reciting passages from Dr. Lenore Walker treatise on battered woman syndrome, Duss versus Garcia. Experts cannot, on direct examination, bolster their testimony by testifying that a treatise agrees with their opinion. This was accompanied by asking Dr. Harper recognized the book as authoritative and then reading quotes from it. Likewise, without objection, the defendant cross-examined Dr. Werner with quotations from this treatise, with either her nor the court recognizing the publication as authoritative. In reference, so then they cite some other information. Examination of an expert with a treatise is only permissible if the cross-examined expert or the court recognizes the publication as an authoritative treatise. For the above reasons stated, the court should deny the request for a new trial on this ground. Ground 5, alleged prosecutorial misconduct by essentially making a second closing argument instead of a rebuttal argument. The defendant, much like her motion to suppress statements, cited no authority to support this ground being improper or grounds for a new trial. This, of course, is no bar to her, again, alleging prosecutorial misconduct. The proper limit of a rebuttal is a reply to what has been brought out in the defendant's closing argument. Brown versus State, and all of the quotations. The state strategically broke up its closing arguments. The first argument was nearly entirely devoted to why the defendant was guilty of second-degree murder. Obviously, there is some inevitable crossing into why it was not justified and why the defendant lacked credibility, but was largely left for rebuttal. The defendant Okay. The defendant nearly 2-hour long closing argument centered on why she met the criteria for battered spouse syndrome and touched upon why this made it objectively reasonable for her fear imminent harm or death if the victim escaped the suitcase, but failed to address the inapplicability of Florida Statute 776.041 to the facts. And the facts were that she left the victim shut in the suitcase after she said he could not breathe and asked to be let out so that she could make him feel how he made her feel in the past, and she could say whether she wanted to him say whatever she wanted to him, and he had to listen to her. It was completely fair rebuttal to distinguish the difference between the defendant's subjective belief that something is necessary versus objectively reasonable for a cautious or prudent person in her circumstances. Likewise, it was fair to attack her credibility as a witness, as that was foundation for her defense, and to point out that even if the defendant's arguments were accepted, she failed to comply with Florida Statute 776.041. In conclusion, there is no right There is no right to jury nullification, Knight versus State. The defendant was placed on notice several times that her version of events did not amount to justifiable use of force under the law. The state's motion to strike the defendant's notice of intent to rely on the defense's battered spouse syndrome, and state's motion in limine for the state's motion for examination of the state's expert. State's motion to strike the defendant's amendment notice for intent to rely on defense of battered spouse syndrome. Oh, he's giving all the dates. Okay, so September 11th, they did that. And then the state's motion to strike the defendant's amendment for notice of intent to rely on battered spouse syndrome, that was September 19th. The state's motion in limine to exclude battered spouse syndrome or exclude mention of battered spouse syndrome until the defendant testifies to justable use of deadly force. That was October 7th. The state's request for forcibly felony instruction and request for initial aggressor instruction, October 21st. State's request for special jury instruction regarding withdrawing from physical contact, October 24th. No version of the defendant's events amounted to a justifiable use of force due to her only stating that she became afraid after she had become angry and aggressed the victim by choosing to not let him out of the suitcase because he made her angry when he said he couldn't breathe. She was going to make him feel like he had made her feel in the past, and she was going to say what she wanted to say to him while he was in captive audience. She admitted to Florida statutes describing as the forcible felony of aggravated assault, Florida statutes 776.0 and 784.021. She was allowed her 10 days in court to ask the jury nullification with past incidents of violence committed by the victim. The court should not grant her a new trial. I certify that a copy thereof has been furnished to James Owens, et cetera, everyone else, Tony Henderson, and that was from Mr. J. And we read the whole thing right on time. It's 1:37 and we're waiting for court to start. Let's see. Court TV has opened up their feed, and let me check and see if Law and Crime seems to always be after Court TV, but don't quote me. Law and Crime, are they live? They have their live set up. No one has gone to sound yet, but I've got them both. All right, let me see what you guys are saying. Let me get to my studio just a second, guys. I'm here, but I'm just not looking at the chat yet, so just bear with me. Hopefully everyone who's here has subscribed to this channel. Hit your notifications so that you can always be notified every time I go live, post a video. There's so much court happening this month, and got to be subscribed and set your notifications to be able to keep up with what is actually going on. Okay, so I'm getting into my studio. Thank you for all of you guys who are here. Thanks to everyone who has hit the thumbs up for me. We have 182 thumbs up, and I appreciate that. All right, well, court should be starting momentarily. I've got both feeds up, so whoever comes first will go there. I don't know, StreamYard was having some weird issues this morning, so hopefully we're not going to have a problem with that today. But Mr. J, he wrote that he didn't, I think based on his argument, I feel like he stuck with the facts. He didn't feel it was snark, which I don't mind I don't not mind a snarky motion at all, but I think he's probably just tired. Like there's so much going on, but I mean that I don't want to just say that part of Florida. I'm not trying to pick on any one particular part of Florida, but let me tell you something. They're busy over there. and nobody got time for that bullshit. You know what I mean? So they're probably just tired. I don't blame them. They're probably tired and don't want to, like, it's like enough already. You know what I mean? Like, Sarah, go away. I would not be surprised if that's how they feel. It looks like lawn crime is on the medallion, so let's and it's spinning loading, so let's just I hope Judge Kranik had a nice Thanksgiving with his family. Let's see. Okay, law and crime, what's going on here? All right, we're going to just let it sit to the background. It's still spinning even off, so I'm not really sure what's going on. But as soon as it looks like law and crime is trying to get it popping. Court TV is still on. They're on this. All right, Court TV has not moved yet. Law and crime have it on the medallion. So we might just leave it here, see what it does. I don't even want to hit on anything because it's been so temperamental today. It's like, what is wrong with you? Let me make sure it's on normal and not on some elevated speed. Okay, so it's on normal. All right. Okay, let's see. In the bushes, everybody's back to work. I hope everyone had a nice lunch. As a Floridian, I will. No part of Florida has time for. Nobody in Florida has time for like. It's nuts, right? I mean, it's nuts. And these prosecutors are busy. They're understaffed. They have very complicated cases. People are out here with the shits. People are doing the absolute most. There's heinous crimes going on right now. And people are smart. And there's some dummies out here too. Make no mistake about that. But there's some people out here who've been very crafty in their foolishness. And these investigators have hard jobs. The investigators, the prosecutors, families are going through it. Nobody has time for this. You know what I mean? So Atlanta, Florida, keep us girls very busy. Girl, Texas too. Girl, you know what? I'm just gonna say everywhere. There are if someone out here covers current events, crime, cases, things of that nature, there is an abundance of stories out here to cover. There is not one boring moment right now. Okay. Judge Kranik has got to be entering into the court for them to be on the medallion because usually they can't go to the medallion until the judge is coming to the bench, but we don't see him yet. But maybe Sarah's on her way in with the shackle shuffle. Guys, this might be our last time with Sarah on that shackle shuffle, guys. Okay. I should check X and see if the people who were in the court last time are there. The lady from Law and Crime, who was there live tweeting, and or anyone else. I'll have to check and see. I don't know why the Law and Crime channel is tripping. She's doing the feel awful and 15-year mark following. Okay. People in the law and crime chat are like, someone just said she's going to feel bad. Someone's saying 30 years. Some people are saying how many. Okay. Let me put up a poll. Before we do anything, let's put up our poll. Okay. Is it life? Hold on. Let's see. Sarah Boone will get sentenced to life. And it's life period. I don't even know. Do they still do like 25 to life? Let's say 20. We know she's going to get at least the minimum. I think it was like 20.5 years life max no parole. 25 years 30 years. We know for sure she's not going home. Okay. I feel like it was 20 and a half. That was the minimum. Okay. Sarah Boone will get sentenced to life, max no parole. The minimum 20.5 years, 25 years, 30 years. Okay, you guys handle that business. Okay. And I've got both feeds on, so nothing yet. So I'm still monitoring. Let me see if I can catch W. Is it WFLA Orlando? Court TV, Sarah Boone is sitting on hold. There's 10,000 people in the lawn crime feed right now on Jamie Komorowski. We might just go over there when we're done. And okay. Hold on a second. There's like damn 10,000 people. It's like let's see. I'm over here on Fox 35 Orlando. They're doing some talking. Let's see what's going on over here. Okay, they're just talking. I'm not going to. It's one of the newscasters talking to one of the newscasters outside waiting. So we'll just leave that as it is. Oh, she came in. Damn it. Hold on. They didn't show the shackle shuffle. They literally just came in and she was already sitting down. Let's see. She's crazy. Who's laughing and smiling on this day? Maybe she got one with the Lord. Maybe God told her something and she's like, you know what? I'm good. No matter what, I'm good. What's that song? No matter what, I'm good. I think it might, I'm not sure. There's a song out here called, it's like, no matter what, I'm good. Girl, there would be no parts of, I would be in tears. Good. Okay, good. So there won't be a trial. Okay. All right. So we'll go over there. I don't know what is going on, guys. It is on the struggle bus of broadcasting right now. So I have to apologize in advance. Okay, so Jamie Komorowski, maybe her lawyers talked to her and told her there was no. They probably had to. I'm sure they talked to her and told her that there was no We'll talk about it in a minute. Yeah, she's got to be nuts. She's nuts. Who's coming in shackles and your blue outfit and you're smiling? For what? You know what? Maybe she saw her boo thing. You know, she's got a lady friend. I don't know if she all of a sudden found her, found what works for her. But there's a lady that she might be dating, and maybe she saw her lady and that made her happy. But baby, them Torreses are in there deep, and she better get her ass. Okay. That's what she better do, is handle that business and get her ass up and down. Notice she didn't turn to the left with that goofy smile. She turned to the right. She probably was smiling at her boo. She might not. I think ma'am is nuts. I'm gonna be honest. I think ma'am is nuts, and I don't think she has the sense God gave a goose. Okay, I don't think she has good sense, and I think that just that goofy smile on such a serious occasion. What is James Owens showing her the latest in technology? Sarah, this is what you've been missing in the last 4.5 years. Look at all the multitasking I'm doing on this phone. Since you love a cell phone so much, let me show you what this does now. Want to see some Facebook? Would you? Oh, hell. Oh my God. Y'all, it's an Amber Alert. It's an Amber Alert, guys. Hold on. Let's see. What's going on? There's an Amber Alert in my area. LaGrange, North Carolina, possibly in Wayne or Lenore. Check local media for information. Why are you sending me? Now I got to go look up an Amber Alert. Court TV hasn't even started yet, y'all. Court TV is like, wait a second. Jamie just put in a verdict. Oh, Court TV's on. Hold on, let's go to Court TV because Law and Crime is tripping. I don't know what's going on, but I'm not touching anything. Well, let's just pray if that's a legit Amber Alert, someone's in distress. Hopefully they get to safety ASAP. Hi, I was waiting to hear back from the agent regarding. Okay. Is YouTube having problems today? Who was that barking? That might have been Portia. I don't think that was Lambo. Lambo barks, you gonna feel it down to your toes. He's got a very oh, Lambo's bark is incredible. That's all I'm gonna say, and I'm not like just bragging because it's my dog. His bark is it's you'll know it. It's like and then he can get real high pitched with it. So nothing's happening. James Owens is showing Sarah his phone. What about his phone? I don't know. But let me try to get this right real quick, guys. I don't know what's going on. James is showing her his phone. I don't know what he's showing her. Yeah, I'm not touching a thing. Okay. I don't even know if I should highlight comments right now just because, baby. All right. After this, I'm going to shut this down and then open a new live and we'll talk Jamie Komorowski what happened. Let me tell you, I feel so sorry for those people this weekend. I did I was doing some research and just looking at the wedding videos and hearing about the impact of the vehicle to the golf cart, seeing the groom in the hospital and the nephew, and just the ripple effect of the accident is just so heartbreaking. And the bride being recovered from the accident in her wedding gown is just horrible. Um, and the fact that there's really just no defense. Jamie was seen drinking at several bars. They've already settled wrongful death cases. There's really no defense other than her trying to work up a deal of time because she can't say she's not guilty. She had the opportunity to be free for a little bit of time, get her affairs in order, but now it's time to go and have a seat. Now it's time to go have a seat. So once everything's done here, we'll pull up the videos and the paperwork and see what her deal was and just talk about it. But good for her taking ownership and accountability for her wrongdoing, and just now it's time to move on. It's time to move on. Let the family heal. Jamie, pay your debt to society. And we don't want to see your ass out here no more. Okay? Married and widowed in one day. Yep. They were on their way to their Airbnb. They were just leaving their reception. They were leaving their reception. They were in a golf cart going to the Airbnb where the couple was staying. And out of nowhere, you know how it is at the beach. They're over there on one of those roads that's like right off from the beach. So they're over. If you've ever been to Myrtle Beach or South Carolina, any of the South Carolina beaches or whatever, and there's like that one road that's like right off from all the houses that are ocean front. It was one of those type of roads. So it was probably dark and not very well lit. And you're just coming from partying on a golf cart. I don't know if they had seatbelts on or not because it's a small vehicle and I don't know that everyone's wearing seatbelts. And have a car going 65 miles an hour hit a little golf cart like that. Can you imagine? They probably flew. I would imagine that they flew. I bet you Jamie's father had a good talk with her. Her father seemed to be a nice guy and he loves his kid, but as a parent, sometimes your kids mess up. And maybe having this time out of jail, she had some opportunity to talk to her parents and have them put some sense into her that this is the right thing to do. Because if you go to trial, you're probably going to get life. Maybe some do, probably mostly don't. I don't know. I'm going to be honest. I've never gone to strap in on a golf. Like I've never in the times that I've been in a golf cart, I've never put on a seatbelt. Usually they're not going very fast. I don't know that I've ever put on a seatbelt to be on a golf cart. I want to be honest. The judge is probably back there trying to. I so see Judge Cranick like, okay, we're offering you life in prison. Look at him as usual. He's probably like, look, you better ask for the mercy of the court. I'm trying to tell you. Look at his body language. It's awful. He's such an ass. But you know what? Sarah likes a little competition in her relationships. I can see that she likes someone who is going to address her a certain type of way because you could tell she gives very much bitchy vibes. What is she doing with all her paperwork? Girl, that paperwork is not going to help you right now. Look how he's looking at her. I don't know where Judge Cranick is, but it's like, sir, please. Oh, so this guy with the bald head right there, that's Billy Lane from Prison Break Investigations. Sarah, is there anything on that paper that's telling you that you're going to jail for, like, let's see what Bougie Gang is saying. Potentially life. Let's see. Right now, you guys have voted 100 and let's see, it's catching up. Right now, it's saying 39% so far, you guys, life. 40%, it's going 39-40, 39-40. 20% minimum, 19% 25 years, 21% 30 years. 40% of you think she's getting life. Interesting. I think she's going to get life too. I didn't even think about it until I really thought about it last weekend. Um, and it makes sense. It really does. It makes sense. And she really undervalued George. She called him Hispanic or something, like it was a racial slur, as if it was like supposed to be a downgrade. Like, I think she had a lower opinion of George for a lot of different reasons, but she used his ethnicity as like a downgrade. Um, she's just particularly disgusting. She's a despicable human being. Um, and I think his family really deserves just stay Hispanic. Like, she said something weird. Yeah, she said that, and it was just weird the way she said it, as if it were to like be a downgrade. You know what I'm saying? Rather than like, okay, yeah, I'll be that. Okay, because yeah, it's, you know what I'm saying? Like, she said it as a slur or as a put down. So his family really deserves the justice. Um, that he really meant something, and he meant something to his kids. He meant something to his mom and his dad. He mattered to his siblings. All of those things. She's just particularly gross. And I hope that she gets a sentence that smacks her upside her head. I really do. She deserves something just for her. And I'm gonna be honest with you. I don't even believe that she went upstairs and went to sleep. I think that just as she put him or let him in that suitcase and did not let him out, I think she probably passed out on the couch or just laid there and waited for him to die. If she was that afraid of him getting out of the suitcase and considered him attempting to get out the suitcase as an overt act, then she had no plans of letting him out. You know what I'm saying? Where was his escape? If he was asking for help to get out and he used his fingers. This is her story, which I don't believe any of her story. He used his fingers and she took that as an overt act. That means you never meant him to get out. And you were so scared you went upstairs and went to sleep. You weren't so scared that you ran outside and got in your car, ran outside and went to a neighbor. You were so scared you hit his hands to incapacitate him, and then you took your ass up to bed. That's just a cold-hearted murder. So, I mean, to me, I really feel like, oh, that's life. She meant to kill him because you gave him no out. You didn't try to help him out. You didn't give him any hopes of getting out. You didn't call the police to help you, to help him, like get you to safety so they could save him. You took your ass. Your story is you took your ass to bed, which is just as bad as I had another couple of drinks and went to sleep. But you got your ass up in the morning, had cigarettes, got yourself a Dr. Pepper, you got yourself situated, called your ex-husband to try to get you out of another dilemma. Girl, that's life in prison. It's life in prison. I don't think she went upstairs. I really don't. I think she sat there. She probably put in a movie. If they would have checked her Netflix account or Hulu or something, she probably was sitting up there watching a movie. That's what they should have checked, her TV account, to see what was on the TV and what she was doing in that house. She probably was watching a movie and waiting to hear him not take any more breaths. She intended to kill him. And if that is the case, I mean, Mr. J and Mr. Cacciatore all but said they did believe her story anyway. So, it's coming on now. Judge is coming into chambers. Okay. There's still no sound, so I don't know what she thinks those papers are going to do for her. Is not doing a damn thing. Let me check on my phone, Jamie Komorowski. Let me go get a water. Are you guys going to be okay if I go get a bottle of water? Girl, the shackle shuffle, sensible creations. If you guys are just now coming in, I read the state's response to Sarah and Mr. Owen's request for a new trial. I think it's going to be denied. Okay. Many of you guys said denied. If you are also just coming in, vote, 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 vote. We are predicting Sarah's sentence. We have 350 in the House. We have 180 votes. What say you? Will Sarah get life with no parole? Will she get the minimum, the mandatory minimum, 20.5 years? I think I'm right on that. I'm not sure. It's something like that, 20 and a half or 21 and a half, 22 and a half. It's something like that. Will she get 25? Will she get 30? What's Sarah going to get? Okay. Go ahead and vote, vote, vote. I'm going to go grab a bottle of water.
Thank you.
Okay. Oh. I'm going to apologize in advance, guys. I don't know. We're lagging today. We'll do our best. I don't know. It's like I go to court TV, it's fine.
Finding you, Miss Boone, guilty of murder in the second degree. We were running a little bit late this afternoon. I apologize for that. I was in court all morning and took the opportunity to review all of your submittals from earlier this morning. Mr. Owens, including the victim or the
Mm.
character statements, the psychological evaluation.
Yeah, today is like a bad stream day because I don't
By
know.
Dr. Harper, the motion for downward departure, the motion for new trial, and the state's response to same.
We're just
Before
gonna
we
we're just gonna
proceed with
try and press
in
on.
sentencing in this matter, the court needs to address the defendant's motion for new trial and the state's response to the defendant's motion for new trial. Anything in addition you'd like to argue at this time, Mr. Owens, over and above what is contained in your motion, sir?
No, sir.
State.
No, sir.
All right. After reviewing the motion and the state's response to same, the defendant's motion for a new trial is denied. Based on the court's review of the record, the court's participation in the trial, and the review of all the evidence, and the court's prior findings and rulings at trial and prior thereto.
Sarah
With
girl.
that, I believe
Sarah
that we're
girl.
prepared to proceed with sentencing at this time. The court has reviewed the pre-sentencing investigation prepared by the Department of Corrections. Are there any housekeeping matters that we need to address, Mr. J or Mr. Cacciatore, before we proceed?
Not from the state.
Are there any housekeeping matters from your side of the ledger, sir, that we need to address, Mr. Owens?
Judge, I do have 4 lay witnesses that are going to testify. I've got Dr. Harper here to testify. Of course, my client's going to testify. But one of the 4 lay witnesses wants to appear by Zoom. She lives up in Minnesota. I don't know if that's allowed.
We don't have an objection to that. One of our witnesses will be providing an impact statement, would also like to appear on the course virtual link as well.
Okay, so stipulated. If you need it, just let Anita know, and I can submit. I can have her email it to you right now. The link.
We do have the link. She's waiting to get on, I guess.
Who might it be, sir? Several people.
It should be Lana Albert.
She is here, sir. She's in the. She's viewing. Her camera's off, and she's microphone is muted, but she's in the lobby.
Okay.
All right. With that, state. You may proceed.
Your Honor, at this time, we would like to take an impact statement from, I believe, Anna Torres, which you will be appearing virtually.
I see several guests, but I do not see a Anna Torres in the virtual lobby, sir.
Well, I think while maybe she's having some issue logging on, we have also in-person witnesses.
We can proceed with those first, sir.
Please call Anna Torres.
Are those, that's mama and that's the
Please.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give will be the truth, the whole truth, and nothing but the truth? Yes.
Ma'am, good afternoon. Could you state and spell your name for the record for us? Okay. Ma'am, you can go ahead.
I just want to tell Sarah Boone that I don't hate her for what she did. And I always remember that evening when that lady came into my door and she knocked at the door. She asked for my name. I tell her my name. And then she said, "Can I come in?" I said, "Okay, yes." And she told me to sit down. I never think that was going to be my son. And then she said my son was dead. Since that day, I can't sleep. It's hard for me to
I feel sorry for mom. Y'all, I am so sorry.
remember that moment. My son is not here no more. She don't only kill my son, she killed a father, a brother, an uncle.
I hope they don't have Dr. Julie coming to talk for a long time. Do you guys last week with Susan Lawrence, that lady that sat up there for damn 2 hours testifying, and it was like, sis, she getting ready to get the full sentence, okay?
It's been hard. I'm a family because all the brothers, they will always work together. But now it's like something real. Love is missing. Sometimes when I look out the window, I'm waiting for him to come and say, "Mom, I love you." She was always there. She come and called me. I missed us, mommy. The last time that I talked to him was at 12 o'clock in January, New Year. He came to my bed and said, "Mom." He woke me up and I said, "Mom, I love you. Happy New Year." Since that day,
He was over there busy with Sarah. So the last time she saw him was New Year's Day. Sarah had him fully occupied over there at that house. He couldn't even get over there to go see his mom. a mess. It's very sad.
I don't see him no more. You know, my son, I love him. And I miss him a lot. My family miss him a lot too. But I don't hear him. But you know what? I was blessed. She ain't gonna be blessed like me because I have my son. I raise him. I have his children, my granddaughter, my grandson, and she don't gonna be able to have that. And I did. I raised him. He wasn't perfect, but he was a good son.
She told her. She said she got to raise her son. I wonder, is that one of the granddaughters or the daughter? Y'all, this thing is lagging so bad. I have to apologize. I hate when this happens.
Thank you, ma'am. State anything further from this witness?
No, Your Honor.
Defense?
No, sir.
Thank you.
Sis works out. This one right here, ma'am works out. Clearly. She might do what is that? CrossFit. She's built. Total gym. She might even be in the military or something. Oh my God. Y'all, it's oh, poor mom.
You may call your next victim impact statement.
So this is the oldest daughter. Okay, so that's George's oldest daughter, I guess, right? Anna Victoria.
I do.
Ma'am, could you state and spell your name for the record for us, please?
Victoria Torres. My name is Victoria Torres. George is my brother. Unfortunately, my family has experienced two horrifying tragedies. I just want to make it clear that George deserves.
Guys, if this keeps lagging, I'm gonna have to shut this down because I don't want you guys to not be able to see like the actual sentencing if my system is lagging like this. So I don't want to have it drag. We'll just have to come back afterwards, but we'll give it like 5-10 more minutes. If it keeps doing this, then I'm gonna let y'all go. And then I'll come back after everything and then we can talk about it. So I don't want to hold it up, like trying to like make this go. And it's just like acting a fool. Okay. And I appreciate y'all sticking over here for a while with me. So, but it's just, it's not doing what it needs to do. So
As far as
yeah, guys, I'm gonna shut this down. You guys meet me over like at Law and Crime or something, and I'll come over there with you guys. I don't know. It's lagging way too much, so I don't want to try to drag this out. But we'll get together a little bit later on and then we'll talk about everything. But I'm going to take, let me go ahead and finalize the poll. We have 215 votes. So far, you guys are saying, let's see, 240 something, 242 right now. I'm going to end the poll. You guys are saying what? Yes, you guys are, Bougie Gang has voted. And what do you guys think? 42% of you guys say life, 20%, 25 years, 19% she'll get the minimum, 17% of you guys say 30 years, 243 of you guys voted. Yeah, it's lagging way too much. So I know this is like, we'll watch it later together. We'll get to the bitter end, but when right now while it's live, it's just not doing. Okay. Another lifer, you think? Okay. Yeah, I hate when it lags like this, but yeah, when I get back from picking up Boo Boo, so maybe around 4 o'clock, it'll be over. If it's not over, we'll talk about it whenever it's over, and then we'll replay the sentence. But I hate for you guys to miss it. So, all right, guys, I'll see you guys in a little bit, a couple hours, and we'll talk about it. All right. You guys take care, and I'll see you later.